I am a living man, capital E, lowercase RIC, of the capital M, lowercase ARTIN family. One of the people, sovereign, not the legal fiction corporate entity defendant with a name similar to mine, and here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
So
just
I've already
standby?
made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel.
Right from the start, he declares himself a living man and refuses legal counsel. That's a classic sovereign move. They believe using certain phrases somehow separates them from legal jurisdiction. In reality, it just frustrates everyone in court.
As I said before,
You got 5 minutes to make your arguments, and you can spend them however you want to.
all right, yeah. Like I said before, I'm a living man. So, as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not. There's no standing, shouldn't move forward. But
This part is fascinating because it shows how deep the misunderstanding goes. He cites the Declaration of Independence as if it's a binding law that can override the court. The judge tries to stay patient, but you can feel her realizing this hearing might go nowhere fast.
oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
As to your motion to recuse, that is denied.
Based on what reasons? Conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of.
Then things escalate. He announces he's filed a federal lawsuit against the very judge presiding over him. This is where it stops being quirky and turns into pure defiance. You can almost see the moment the judge decides, enough is enough.
Okay, so they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. So I was all within my right under that federal statute.
Here's the core argument sovereign citizens always return to. I was traveling, not driving. They claim you only need a license if you're doing commerce. Courts have rejected this for decades, but it keeps resurfacing in every state.
And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other two. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request of police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes. Penhallow versus Jones Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI.
And this is where the prosecutor absolutely destroys his logic. She calmly points out that his case law doesn't even exist. It's literally copied from online sovereign templates. The calm professionalism here makes the contrast even sharper.
To say again what I missed, and then I can respond one by one. Okay.
That's not how this is going to work, sir.
That's
I
not
think
how.
To understand here,
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this works.
I'm speaking about what I have a right to do. I have a right to respond back. So
You're going to get 5 minutes and I'm going to be done. So that is your opportunity. And after that, I'm going to make my rulings. You got 5 minutes. I'm actually setting a timer.
All right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now, please move forward.
Criminal. I want to object to that too, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
Now the judge finally snaps, politely but firmly. She warns him about contempt. but he still argues it's his First Amendment right to keep talking. At this point, the courtroom has turned into a one-man legal seminar on nonsense.
To prosecute their own cases. In Article 1, I forget the exact section. But I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection it was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also, the U.S. Supreme Court case Murdoch versus Pennsylvania. And I got the volume number, page, and all that. I think I said to you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something. A right's a right. Bringing something to the court's a right. Be heard is a right. I don't have to pay money for that. Criminal or civil case. Okay, so it violates due process. So all that's legitimate. They're illegitimate, that is. Their arguments are using for that. Supposed to be acted on regardless of a prosecutor's approval or not. Okay, anyways, now as to her asking who's Mike, he's the manager at Area Towing. But we should have read it. It was in that document to explain that. So, okay. Anyways, as to the Penhollow, what she said about the quote about the Penhollow case. Okay, now first I want to say, regardless of the Penhollow case, what she said, the Declaration of Independence of 1776 makes it clear the government has no power over the people. They derive their power from the consent of the governed anyways. That's something that's clear right in there. Okay. The consent of the governed. I never consented and never will. So, number two, now her saying about the quote, I was just recently going to the law library. I'm going to need more time to respond to that. But I didn't have enough time to go over the Penhollow case, but if I remember it, I was just in the law school law library recently trying to verify that quote, because a lot of these quotes that I got, that I'm citing in the court, some of them I have read and some of them I haven't. This Penhollow case, I'm not sure on that. I admit that. I have to double check myself because a lot of these I get online, YouTube, and a lot of them have been shown up to be legit because I go to law library and I double check on them, the quotes. In the Penhollow case, if I vaguely remember, I think I did have a problem myself finding that quote, saying that exactly like that, but that's not saying it doesn't stand for that proposition. I'm sure it still does. I just got to go back to the law library and read it again. If I did read it, I kind of don't remember because I got a lot of stuff I'm doing. But yeah. So bottom line, I gotta check up on that case. So it'd be premature to rule on it yet, as to whether that Penhollow case is illegitimate to stand for that proposition. But I know U.S. Supreme Court cases still say it because it's all based off the Declaration of Independence. So there should be no doubt on that. And U.S. Supreme Court cases exist that say that Declaration of Independence is part of federal law, United States Supreme Court law, and it's the basis of the Constitution, so it's legit. That, as of the proposition that governments have no power over a human without our consent. All right, now, as to the summary judgment.
By now, the judge and prosecutor both know there's no reasoning with him. What's wild is how calm they remain through it all. It's a reminder that in real courtrooms, patience isn't just a virtue, it's survival.